Morning. Welcome to Division 2 of the Colorado Court of Appeals. I'm John Daniel Daly. I'm privileged today to be serving on my right with Judge Ted Tao and with on my left, Judge Russ Carparelli. Today we have, I believe, two cases on our 9 o'clock docket. The first case is People v. Guevara. Is that a correct pronunciation?
I believe it's Guevara.
Guevara, thank you. Thank you, appreciate it. The second case is McCauley v. Department of Revenue. I know the counsel are here for the first case. Counsel here for the second case?
Petitioner is represented. I'm willing to finger.
Yes, Your Honor. Vince Morris here from the Attorney General's office.
Okay. Please have a seat. When you first came in today, you should have stopped by the bailiff's desk and received some written oral argument instructions. Did y'all get those? Okay. That's okay, Mr. Finger. I appreciate it. You're okay from here on, and you can relax a bit. But I do appreciate the respect shown to the court. Do you have any questions about the directions in the written oral argument procedures? No? No questions? Okay. Then I will give just a couple of reminders. Remember that our arguments are being live streamed and they're also being recorded on the judicial website. Please be careful about relaying sensitive or confidential information. Don't give a minor or sex assault victim's name, proper name. When you come to the podium, give us your name and registration number. For appellants, you're in control of your own destiny. Watch your time. You can reserve whatever rebuttal you have left after our questioning of you, of course. And then also for everyone in the audience, please turn off your electronic devices, your pagers, your cell phones, so as not to disrupt either the court or the advocates in their oral arguments. With that, I think we can begin. In the case of People v. Guevara. Thank you.
May it please the court?
There should also be an adjustment on,
right.
There you go.
I'll use
You can
that.
adjust that.
That's helpful, thank you. May it please the court? My name is Shan Jeffrey. My registration number is 28689. I'm appearing on behalf of Orlando Guevara. Your Honors, we are here today because a different division of this court remanded to the trial court to hold a supplemental Batson hearing in appeal number 17CA851. It ordered that the trial court should reconsider the Batson ruling, given that originally the trial court's initial ruling occurred after step 2 of the Batson analysis. The question for this court is whether, following the record made at the remand hearing, the trial court clearly erred by denying the Batson challenge after the prosecutor struck 3 young women of color from the jury box. Review for clear error is generally a deferential standard of review. However, this case is the exceptional case where the record clearly demonstrates the court's error in denying relief on the Batson challenge. The denial of the Batson challenge was clearly erroneous for 3 reasons. First, the remand proceedings were flawed. Second, the trial court's legal analysis was erroneous. And third, the totality of the record evidence clearly establishes that D.A. Bauer used race as a criterion in striking these 3 young women of color from the jury box. First, I'll talk about the flawed remand proceedings. As a matter of law, the trial court erred when it considered and credited the post hoc justifications of the new prosecutor who was not present for jury selection and had no firsthand knowledge of D.A. Bauer's state of mind when using her peremptory strikes.
As a matter of law, what authority did you cite in support of that proposition, counsel?
Well, in Miller v. Drecke, Your Honor, for one, this language appears.
This what?
The following language appears in that case. If the stated reason, it's talking about the striking prosecutor's stated reason, does not hold up, its pretextual significance does not fade because a trial court or an appeals court can imagine a reason that might not have shown up as false. And in that same vein, if the original prosecutor's stated reason does not hold up in light of the comparative juror analysis argued on remand, its pretextual significance does not fade because a new prosecutor can imagine justifications for striking the color, or for striking a juror of color that might have seemed more comprehensive or more credible than those offered by the original prosecutor.
So the court ruled that you could not consider those, or you could not consider those justifications in Miller L?
Right, in Miller L.
And which Miller L was that?
Miller L v. Drecke. I can give you the site when I come back up if you'd like.
Did you cite that for that proposition in your brief, counsel?
I believe that was cited in my brief. There's also a whole list of cases cited in my reply brief that talk about post hoc justifications not being legitimate criterion
In this case,
for consideration.
as I read the record, the striking prosecutor said she wanted to allow the juror to take her exams. And then the subsequent prosecutor simply fleshed that out, saying exams are clearly different than just going to class. Is that really a post hoc rationalization, or is that just pointing to what she had originally said?
Well, it's a post hoc rationalization because, for one, the second prosecutor, who was not there at trial, framed his argument in terms of, in my opinion, or how I would look at it, and that is irrelevant because he was not there. The only relevant inquiry is what was the subjective intent of the original prosecutor at trial. I can give you another cite from Miller L., Judge Daly, and this one is at 545 U.S. 231, page 252, and that's the 2005 case, where it says the original prosecutor's actual motive for peremptory challenge is all that matters.
This is true, but remember, we've also had a series of cases that indicate that sometimes these proceedings are remanded years after trial. And I would think that it would not be totally unexpected that the original prosecutor might not be available. So might there be other indicia to which you look to see whether or not the prosecutor's original indication of reason would have been pretextual or credible?
Well, I would argue, Your Honor, that even if the original prosecutor was no longer with the office at the time of remand, that a diligent new prosecutor would call that former prosecutor as a witness and put them on the stand for what their original intent was.
Was that argument made to the trial court below? Was there any objection to the appearance or the arguments of the new prosecutor below?
Well, there was no objection to the appearance because it's not inconceivable, like you said, that a new prosecutor would appear on behalf of the people. However, there was no indication in the remand order that this new prosecutor would be allowed to serve rebuttal argument at the remand proceedings, so there was no objection prepared for that either. The court simply, after hearing, at step 3, after hearing what should have been the argument just from defense counsel on why the stated reasons in step 2 are pretextual, the court simply turned it over to the new prosecutor for argument. But that is not part of step 3 of the Batson analysis, Your Honor.
Well, is it within the court's discretion to allow the prosecutor to respond in any case to the rebuttal of the defense?
For sur rebuttal at step 3?
For sur rebuttal?
I don't believe it's a discretionary matter to go outside of the boundaries of step 3 of the Batson analysis.
Do you have any law to that effect?
I don't have any authority to say it is permissible.
You don't have any authority saying it isn't permissible?
The only authority I have saying that it's not permissible is the step 3 of the Batson analysis described in all of the cases that refer to the defense having the opportunity to give that rebuttal argument. I think it ends there. I think it's plain.
In fact, the defense has the burden at that stage, correct?
Exactly.
So why is the absence of the original trial prosecutor not at the feet of the defense attorney, not at the feet of as opposed to at the feet of the prosecutor? In other words, if the information isn't there because the prosecutor wasn't there to testify, whose fault is that when the defense carries the burden?
I don't think the defense had any obligation to call the original prosecutor. The prosecutor, could you restate your question?
Your assertion, as I heard it, was that the prosecution should have brought in the original prosecutor to explain why she did what she did. But she'd already explained why she did what she did on the record years ago. So if the defense wanted to challenge that, to carry their burden, wouldn't it be on their plate to subpoena that individual, to put her on the stand if you wanted her to testify?
I see what you're saying. Well, I think once you get to step 3 of Batson, the allegedly facial race-neutral reasons have already been given from the prosecution, like you said. However, because the court halted at step 2 instead of going through step 3 in the original proceedings, the defense counsel had the chance, as it should have, to use the record evidence already in the record, including a comparative juror analysis, to show that those reasons were pretextual. If the prosecutor, the new prosecutor, wanted to talk about the subjective intent of the old prosecutor at the new remand hearing, then I think that argument needed to be informed by the original prosecutor. I don't think that argument should have been made at all, frankly. I think it ended with the defense argument. But if they were going to allow the new prosecutor to talk about subjective intent, it sure better be based on record evidence and not what he would have done. What he would have done in the old prosecutor's shoes was not relevant, and that's what he talked about.
When the prosecutor talked about the subjective intent of the original prosecutor, didn't the prosecutor confine its remarks to, Judge, she's not here, but you did find her credible years ago?
No, because if you look in my brief where I quoted what the new prosecutor said, he actually said things like, in my opinion, and if this had been my strike, things like that. So the prosecutor was basing a rationalization on his own prosecutorial experience that didn't comment at all on the subjective intent of the original prosecutor.
Wasn't he just doing the comparative juror analysis and saying, well, they're not really similar?
No, I don't think so, because it was a post hoc rationalization. It was post hoc because he wasn't there, okay? He wasn't there at the original Batson hearing. Therefore, he's reflecting back on what he understands of the record now. It's also a rationalization because he's not talking about the subjective intent of this prosecutor. That was not his role. He didn't have that personal knowledge. He's only talking about what he would have done in her shoes or how he would have looked at it.
Why is it a post hoc rationalization if he's looking at the record and saying there's a difference between the jurors in the record?
Because he talked about his own personal opinion, Your Honor. And he talked about how he would have looked at it. He did not confine his comments to what was in the record.
But what if the trial court confined its analysis? And the prosecutor says, in my opinion, but the trial court says, regardless of what his opinion is, I'm looking at two jurors who aren't similarly situated.
But the judge didn't say regardless of what his opinion is. The judge based its observation or its ruling on the argument of the new prosecutor, at least in part, because it mimicked what the prosecutor said. So the legal analysis was erroneous in other ways, not only because it considered the post hoc rationalizations of the new prosecutor. In Dretke and in Snyder, the Supreme Court stated that in reviewing a Batson objection, all of the circumstances that bear upon the issue of racial animosity must be consulted. But here, the trial court had no recollection of D.A. Bauer's demeanor by the time the remand hearing occurred. And the court erred in concluding that it even had the capacity to find D.A. Bauer credible based on a totality of relevant circumstances. Clearly, D.A. Bauer's demeanor was a relevant consideration, but the trial court was incapable of considering it because it lacked sufficient recollection. The fact that D.A. Bauer's explanations may have seemed credible to the trial court during jury selection are no longer reliable, given that the trial court's initial credibility determinations made at trial were not informed by step 3. In Snyder and in Valdez, our local case, the Supreme Court concluded that where there was no realistic possibility to profitably explore the prosecutor's motivation for striking a juror of color more than a decade after the trial, or after a long period. In the Valdez case, it wasn't a decade. Reversal of the lower court's ruling denying relief on the Batson challenge was the appropriate remedy. I'm just going to say one more thing, and then I'm going to reserve the rest of my time for rebuttal.
Counsel,
Yes.
you're going to get 2 more minutes for rebuttal because we've been taking up quite a bit of your time. If you want to use 2 minutes now, you'll still get your 2 minutes more.
Okay, thank you. Here, the totality of record evidence clearly establishes by a preponderance of the evidence that race was a motivating factor in striking these 3 young women of color from the jury box. A comprehensive analysis of the record here reveals the disproportionate frequency of the striking of the young women of color, which is 50% of the peremptory strikes. The particular striking sequence here, which was that DA Bauer was satisfied with the jury each time until a new woman of color got into the jury box. The pretextual reasons offered by the prosecution for striking these jurors of color, especially with respect to Bacall, and the strategic motive for the prosecution to eliminate jurors of color from this case. These all prove the Batson violation. Thank you.
Okay, when Ms. Jeffrey comes back for rebuttal, please add 2 more minutes to her rebuttal time. And counsel, you will have 2 minutes extra as well.
May it please the court, my name is Ellen Neal. My registration number is 43885. I'd like to start by responding to something that was raised for the first time in the reply brief and also has been discussed here today. The defendant is asserting that the Batson violation here is that the prosecutor was striking young women of color. And I find this to be concerning because this was not the Batson challenge that was raised below. This was raised for the first time in the reply brief. It was not raised in the opening brief. It wasn't mentioned at the remand proceeding. I don't believe it was raised in the first round of appellate briefs, and it certainly was not raised at trial when the defendant lodged his Batson challenge. The Batson challenge that was raised at trial was that the prosecutor was striking people of color. So the age and the sex of the jurors was never raised below. And for this reason, I don't think that the age and sex of the jurors is actually properly before this court. We know that claims made for the first time in reply briefs generally are not considered by this court. And in regard to Batson, claims that aren't raised below cannot be raised for the first time on appeal. And the reason for that is that it fails at the first step of Batson. The defendant, at the first step of Batson, has to make a prima facie showing of discrimination. And here, when the defendant fails to argue that age and sex are part of the pattern, those claims fail at the prima facie showing. So I don't think the age or sex are properly before this court. I'd like to respond a little bit about the claim that the remand proceedings were flawed in this case. It's my opinion that the court could completely disregard the new prosecutor's comments, and the record still supports the original prosecutor's reasons for striking these particular jurors.
So you would agree with counsel then that the participation of the new prosecutor was improper?
No, that's not what I'm saying. I'm saying if this court gets there, it doesn't even matter to the ultimate result here. I think the new prosecutor can certainly comment about what the cold record shows. And that, when you read his comments in context, is what he was doing in this case. He wasn't saying that this is my subjective intent. I absolutely agree that the second prosecutor's subjective intent is not what we're analyzing here. We are focusing on the first prosecutor's subjective intent. But what the cold record shows, I think, is certainly something that can be commented on. I'd also like to comment about the absence of the prosecutor. Again, this was something I think you pointed out that was not raised below, and it is the defendant's burden to carry a Batson challenge and to show that the court's findings are clearly erroneous. To the extent that there was any issue with this, it should have been raised below.
What about the reference to Miller L? Does that suggest that a new prosecutor's thoughts or arguments are irrelevant at a Batson hearing?
I've read Miller L, and I don't recall that being in there. I'm not saying it's absolutely not, but it's not something that jumped out to me. I would point out that in Craig v. Carlson, which comes out of our Supreme Court, fairly recently, I think within the last 10 years, that case actually involved there had been an erroneous finding that gender was not a proper Batson consideration, so there were no Batson findings at all at the trial level, and then a new judge came in and did Batson findings for the first time after the trial, and at that point, one of the parties brought in new reasons for its Batson challenges, and it wasn't the issue that was before the Supreme Court, but the Supreme Court didn't seem to have any issue with that procedure and new information coming before it that way. Something that I want to point out about this case is that we had full Batson findings at the trial. This case was remanded because in the prior division's opinion, the defendant did not have an opportunity to respond. But this isn't a case where we haven't had a full Batson proceeding. The prosecutor explained the reasons for her strikes, and the court credited those at that time. And so I think that is unique to this case.
What do you want us to do about that, counsel? In other words, you said there was a full Batson hearing. Apparently, the prior division indicated something was missing.
Yes, the defendant had not been able to explicitly comment on it. Frankly, it's been the position of my office all along that they did in fact have an opportunity and chose not to comment. That ship has sailed. But I think that this was, it was sent back, the remand occurred, the defendant was able to make the record that he wanted. In my opinion, it was not a very compelling case of a Batson violation, and the court was able to consider that it had previously credited the prosecutor and to look at the cold record and see the strength of the reasons for the strikes. And so I think that's absolutely appropriate.
Right. I was going to say the remand order was allow the rebuttal, which should have been allowed originally, and which apparently disagreed with your office's position.
Right.
And to reconsider the Batson
Yes.
ruling.
Yes,
And that's what I think we're reviewing at this point.
yes, right. And I think the court can, though, consider its prior findings of credibility, especially when we're talking years down the line. And I'd like to discuss the pattern count, or not count, the pattern claim in here. When we're discussing a pattern of discrimination, I think it is certainly relevant to look at the strength of each strike, and here we have very strong reasons for each strike. I also think it's relevant to look at the strength of the alleged pattern of discrimination. And here we have an African American, we have a woman who was born in India, and then we have an Asian woman, and that is supposed to be the pattern. And frankly, that's not really a pattern at all. So I think that's something that the court at least implicitly considered. Something else I think when you're considering
Why
whether
is that not a pattern?
they're different racial groups, and I just don't know how that is a pattern. This isn't, I think in some of the Batson cases, there is a very clear attempt by the district attorney's offices to get African Americans off the panel, and so you'll see all the peremptory challenges against African Americans. Here we have three people from very different backgrounds, and I think it's very easy later to come back and say, oh, there's a pattern when there really isn't one. We would have an equally strong pattern of striking white jurors in this case, and yet nobody is saying that that actually occurred.
But there were no other people of color left after these three strikes, is that correct?
No, that is absolutely not correct, and that's actually something else I think that can be considered when we're talking about a pattern of strikes. Unfortunately, in this case, I don't think we have all of the jury information in front of us. Usually there'll be like a final quick cheat sheet list of the jurors who actually served. So you have to go back through the record and look at who was seated where and who was there. And I think I outlined this in my brief, though. We can clearly tell that there was an African-American woman who did serve on the jury. There was a woman from South Korea who had been born and raised in South Korea. According to her questionnaire, she served on the jury. And there was a Hispanic man who had been born in Mexico who also served on the jury. In addition to this, there was a Vietnamese man who had been born and raised in Vietnam who served as an alternate. So this, I think, is a proper consideration for this court, that we do, in fact, we don't have a completely Caucasian panel. And tellingly, these jurors were on the jury when the prosecutor accepted the panel. The prosecutor had one more peremptory that could have been used that she never used, and she left these jurors on and did not strike anyone until the third juror, who she then struck for exam reasons. So I think that's certainly a consideration. Does this court have any questions?
I just want to be clear. Is it your office's position that in order to establish a Batson violation, not necessarily in this case, but in general, it seems like you're saying essentially they have to share an ethnicity as opposed to sharing just not being white?
I think that it probably depends on the case. I think there could possibly be cases where people are just kicking anyone who's not white. But I think it's one of several considerations that we have in this case.
Counsel, let me ask you about this pattern. I would suspect that the pattern could be taken into consideration, for purposes of a step one Batson analysis, an inference of discrimination, whether or not you need to go to step two and step three. As I understand the remand hearing, defense counsel largely took the position that, may have totally taken the position that the one African-American juror, the strike to her, was considered for step one purposes, but really didn't have much to do with the step three analysis. Is that correct?
My understanding was that at trial, and again at the remand hearing, I think that's correct, that the defendant agreed that there were race-neutral reasons for striking that juror. And when you look at the record, there is absolutely many reasons for striking that juror, any one of which would have been sufficient, and together was more than sufficient. So I think that's correct. Before I sit down, I just would like to point out that Batson is supposed to be an extraordinary remedy. It's only when it's clear that this is a race-based or discriminatory strikes that this court can reverse, and I just don't think that that's something that's available here. As I pointed out, the first juror was properly struck for a variety of reasons. The second juror was clearly late to the proceedings, and in fact, it was the defendant's suggestion that she be dismissed. Now, for cause, and for whatever reason, she was not actually dismissed for cause. But again, what we have is the defendant agreeing that this is a race-neutral reason for getting rid of this juror. And then the third juror had exams, and there's been, I sense a question.
Yeah, you do have a question. I appreciate that sensitivity. For whatever reason, it wasn't struck for cause. Could it have been that she was only a couple minutes late? It wasn't like she was really, really late. She was a few minutes late. Maybe that's the reason why she wasn't struck for cause.
I mean, the record just isn't clear as to why she wasn't dismissed. She was just a few minutes late. I think that's probably fair because the prosecutor was in the beginning of her opening spiel with the jurors when that juror finally came back. So it is possible that something happened off the record, maybe. It's not in the record why she was not dismissed. The point is that the defendant agreed that this is a reason to dismiss someone. And again, we also have another consideration, which was that the prosecutor saw her sleeping during the proceedings, and there's a lot of case law indicating that this is absolutely a proper reason to strike a juror, whether or not the court has actually seen that demeanor-based reason for a strike. And if there are no further questions, I'd ask that you affirm. Thank you.
Counsel.
A couple of points in response to that. First, I am unaware of any case out of the U.S. Supreme Court or otherwise stating that jurors of color who are struck from the box must be the same ethnic minority in order to constitute a pattern of discrimination. Second, the sex of the struck jurors is before this court and was at the remand hearing because in this court's slip opinion in the last appeal on page 26, the court stated that the prosecutor exercised 3 peremptory challenges to excuse female jurors of color. So the court has already recognized that the pattern of strikes encompassed not only jurors of color, but female jurors of color. That was presented to the trial court on remand. As far as the age of the struck jurors, whether that's relevant, here's why it's relevant.
The question wasn't whether it was relevant, counsel, it's whether it's properly before the court.
Right. This is why it's properly before the court now, given the briefing that has occurred. So part of the state's argument in the answer brief was that the alleged presence of an older African-American juror proved the lack of discriminatory intent toward the struck jurors. But if you look closely at her age, which I believe she was in her 60s, even if it's true that she was noticeably African-American and she was on the jury, which I'm not conceding because that's not part of the record, this older woman would not have fit the particular striking pattern here, which was young women of color. And the more you can define a profile for the striking pattern, the more likely it is that that profile included race-based criterion, the more likely that the pretextual reasons, the reasons given for those strikes other than that criterion are pretextual.
But counsel, you're conceding that you didn't raise that until after the answer brief, and don't we generally not, as a court, allow you to bring in a new justification, a post hoc rationalization, if you will, of your argument purely raised in the reply brief?
But I think if it's responsive to what was said in the answer brief, it's allowable. It's
Everything
responsible.
in the reply brief has to be responsive to the answer brief, or otherwise it wouldn't be appropriate for the reply brief. So the exception would swallow the rule.
So I'm not saying that in the trial court originally, the original Batson objection was based on age, color, and race. What I'm saying is that we can look at the jurors that were struck and we can see what their common characteristics were in order to define the pattern, the striking pattern, because that's one of the only ways that we can interpret the prosecutor's subjective intent based on facts established in the record. The record clearly establishes that these were young women of color.
How does young and women affect whether it was a race-based challenge?
They just all share those characteristics.
Yeah, but how does it affect or reflect on it being a race-based
Right.
challenge?
So if one of those criteria is race, right, which it is, if they're all young women of color and one of those criteria is race, and it shows that there's a profile of striking, that simply lends support to the idea that there was a striking pattern for a particular type of person that included race.
Thank you, counsel.
Ms. Jeffrey, the People's Brief identifies an African-American juror, an Asian juror, and a Hispanic juror, and in arguments she mentioned that. Are you saying there's no record support for that?
I am saying that at the remand hearing and in the original Batson hearing, neither party or the court ever entered into the record what the racial composition of the sitting jury was. So in order for opposing counsel to try to reconstruct that, she had to use 2 pages of single-space footnotes to show why she believes that the racial composition of the jury is how she stated, but it is not in the record.
Was she incorrect or correct?
I wasn't there.
Thank you, counsel.
Thank you.
Thank you both, counsel, for your arguments. The case will stand submitted and opinion will issue in due course. Thank you for excellent arguments. you want to get any water, counsel?
No, I'm fine, thank you very much, Your Honor.
Okay. Okay, I think we're ready to go then in our second case, which is, I believe, McCauley versus Department of Revenue. Counsel?
Thank you, Your Honor. May it please Your Honors, I'm William Finger, registration 7224, and I represent Ms. McCauley in this proceeding. My initial remarks are going to be brief. I'm going to reserve the remainder of my time since the appeal that we filed relates to the attorney fee award rather than the merits, but I briefly want to talk about the merit issue just to focus it. This is a case where Ms. McCauley, a employee of the department, worked in one of the Western Slope offices as a revenue person in the driver's license section. And after a period of time working there and having some problems, she submitted a letter of resignation. And then, before receiving any acceptance of the letter of resignation, retracted it. The department took a position that she could not retract it, and the matter went to the Personnel Board, the constitutional entity that controls personnel actions. The question then went to an administrative law judge who decided a motion to dismiss by the department, finding that the motion should be denied and making detailed findings concerning what the State Personnel Board rules and their application meant. The judge offered the department an opportunity to submit those findings as the law of the case to the board for review, because the central question came down to what is a voluntary separation, and within that process, when you submit a letter of resignation, can you withdraw it? And that was an ultimate legal conclusion that the ALJ found that was appropriate for the board's consideration if the department would agree to submit that. The department refused, wanted to go to an evidentiary hearing, developed no new facts in that process, and submitted no new evidence. They were given an opportunity to show estoppel or some type of bar from submitting the letter of retracting the resignation, but they chose not to do that.
Counsel, did you at this hearing or at any time in the proceedings ever raise an estoppel argument on your own? And that is, gee, there used to be a rule and it's still on the website, or at least it's
We
supposed
did. We argued that.
And did the ALJ make any findings?
She did not, because she based her findings on the concept of resignation under Board Rule 1-65. And we submit that that is the key to understanding this case. And that is, resignation is a voluntary separation from the state personnel system. And the question then became, is that rule mean when you submit a letter that you're going to resign in the future, or the actual leaving of employment? And that was the question that was before the ALJ, and she found, and the board found, that the resignation under that rule, the meaning of that, is when you leave, not when you submit the document. And we submit that that determination by the board is a matter for the board's constitutional authority that's been granted to them to interpret and make rules and apply those rules in the personnel system. That is not a job for the court.
If we were to disagree with you in some manner on that particular issue, would a remand back to the agency be appropriate on the estoppel issue? On the estoppel issue that you had raised?
Sure, it could be.
Yeah.
It
But-
could be.
But there's no need.
The issue also applies to Rule 7-1, which they found. 7-1 says if it isn't voluntary, that they have to have a interchange the appointing authority and the employee, which they did not have. So the board found under two situations that Ms. McCauley prevailed. One, there was a violation of 7-1, and two, that the resignation was, the retraction of the resignation was all right. There is another issue that wasn't raised by the department, which was, if you can resign, is there a situation if you accept, if you give a written acceptance which is received, will that preclude the individual from rescinding? This case, that issue wasn't raised because my client didn't receive that. It could have been raised.
Counsel, is it your position that well, first let me state what I believe to be the premise of the ALJ's ruling, which is that there is a constitutional right to withdraw your resignation up until the moment you walk out the door.
I think the premise of the ALJ's ruling was that the Constitution supports the concept that the resignation is not effective till the day you actually have are leaving.
And is it your position that the Constitution allocates to the state board the ability to interpret its own constitutional authority to the exclusion of our review?
No, my interpretation is that the authority of the board to promulgate regulations and interpret their regulations can only be challenged in a court if their application is unconstitutional.
So you're not saying this was a rulemaking process?
No, it's an interpretation of what the existing rules meant, and specifically 165 controls. In state legislation, in the legislature, they've said an employee can resign, but they don't interpret what that means. Now, the legislature could interpret it, or the board could interpret it. That's their jobs, either the legislature or the board, to make that interpretation. It should not be the court to make that interpretation because a constitutional principle is not at stake here.
Except for the fact that the ALJ decided it in the context of a constitutional right to retain employment.
Well, she looked at that issue, yes, but that, I don't believe, was the sole basis of her opinion.
Can we roll back for a moment? You asserted lack of jurisdiction of this court
I
in
can.
terms of the lack of final and appealable order.
Right.
If that were the case, would we also not lack jurisdiction to resolve your attorney fee appeal? Because now I understand there's an exception for calculation of attorney's fees, but there has to be a final judgment before anything is appealable. Is that not
Theoretically,
correct?
you could do that. The problem is the decisions that have been made distinguishing appeals of attorney's fees and finality of that versus merits litigation.
But is there any case where an appeal of the attorney's fees has been allowed to be pursued before the merits, as opposed to just distinct from and usually after the merits?
I'm sorry, would you repeat that question because I got to go back
Are you
in
aware?
a long history of
The-
working personnel court cases to think about.
The cases generally do say that if attorney's fees as costs have not been finalized, that's a separate issue. We don't have to wait for that to deal with the merits appeal, right? But I could find no case where the merits appeal was not yet timely, but the attorney fee appeal was allowed to go forward. It's usually the other order in time, is it
Well,
not?
in this case, the appeal on the attorney's fees was taken because it was, the decision overruled it.
I understand that, but the premise...
If the board had ruled in favor of the attorney's fees, then it would all, I think, flow.
I understand the timing of it, but the premise of the jurisdictional requirement of a final and appealable order is that we not waste time, right? If, for the sake of discussion, if we reverse the ALJ If we were to say, there's no jurisdiction yet on that because the damages weren't calculated, there's no final judgment. So we dismiss that part of the appeal, but we'll deal with your attorney fee part of the appeal. Then later, that case gets resolved, the damages are finally calculated, it comes back, and just for the sake of discussion, the ALJ's decision is reversed, your attorney fee award becomes moot. So if there is a jurisdictional problem, is it not encompassing the entire case?
It might be.
And in terms of that, what remains to be done for the merits? The calculation of back pay?
Calculation of back pay and benefits.
And is there a dispute, or is that simple calculations
Oh,
and
no, it's
and
not a simple
arithmetic?
calculation because you have to offset alternative employment, alternative distinction between Social Security contributions and para contributions. It can become a very complex type of calculation. Also, there may be other damages associated. For instance, you can offset costs for seeking other employment, et cetera. So it can be a complicated evidentiary process.
Thank you.
Lastly, I'm going to address then the issue of the board's reversal of the attorney fee award. There is no findings as to that basis. We think that is clear error by the board, and that the cases we've cited, including Ritzer and Bob Blake Builders and Stearns Management, demonstrates that was clearly arbitrary and capricious action and improper, and the record does support an award of attorney's fees if we prevail on the merits. Thank you. I'll reserve the rest of my
Can I
time.
ask a question on that? Because the attorney fees were awarded on the basis of a party being stubbornly litigious, is that correct?
Yes, it was.
Okay, and why was the other side being stubbornly litigious if they had good faith arguments for going forward?
The request for attorney's fees was solely for the period following the summary judgment order and the evidentiary hearing where there presented no new evidence beyond the summary judgment issue. They could have preserved their argument and determination by moving immediately to appeal and not requiring an evidentiary hearing. There was nothing offered in the evidentiary hearing, and they kept rehashing the same old argument that they lost, causing the expenditure of attorney's fees in pursuing the case.
So is it the case that the board procedures allow for what would be the functional equivalent of a 54B certification of a legal issue?
They could have done that, and the ALJ offered it to them.
And that's within the board procedures to allow that?
There is not, the board procedures don't specify that, but it was clearly appropriate. They could have also sought declaratory relief under board rules. The board rules do provide for declaratory process. And there was no indication if they had gone that way, there would have been an objection from Ms. McCauley. It could have gone forward on a stipulated factual record to the board for a board determination. Thank you.
May I reserve time for rebuttal on the cross appeal?
No.
No. Okay. Good morning. My name is Vincent Morsher, Senior Assistant Attorney General, representing the Department of Revenue. Registration number is 34816. May it please the court. David Lindsay is the appointing authority in this case who made the decision that brings us here today. Mr. Lindsay used his discretion to decide not to accept Ms. McCauley's resignation withdrawal. In doing so, he relied on a couple of different authorities. First of all, he relied on the board rules and the fact that there was no longer a board rule that permitted withdrawals of resignations. The other board rule relied on was the general discretion rule that gives appointing authorities and departments the ability to decide whether to take an action where there is no board rule that covers what that action would be. Mr. Lindsay additionally contacted the Human Resources Director of the Department of Revenue and understood from him that because the rule was rescinded, there was no longer a rule that guided how you handle resignations, and that the department general procedure and practice is not to accept withdrawals of resignations.
So if that's the analysis and the ALJ essentially rules that a non-case specific application of that rule is an abuse of discretion, would that not be something we review on a different standard than the argument that a person doesn't have a constitutional right to withdraw? In other words, the latter one is a legal conclusion as to what the Constitution affords the employee, correct?
Correct.
But if this isn't a case about whether someone has a constitutional right to withdraw, but you're asserting that the deciding agency can, in its discretion, allow it, did the ALJ not simply decide that they abused their discretion because they didn't consider her work record, they didn't consider the needs of the office, et cetera?
Well, I don't know if the ALJ said it was an abuse of discretion what the agency did. What the ALJ bought the idea that there is some ability for the employee to argue that there is a work issue that would affect the discretion that the appointing authority would make. But that's not the case. The employee is not able to sit there and say, listen, you guys have a workload need here, you're out in a rural area, and so therefore you should let me stay. I mean, certainly that's up for the appointing authority to decide what to do, and so the ALJ didn't say he abused his discretion in making his decision. What he did is he relied on the rules that were there. He relied on what the board put forth to guide agencies and appointing authorities on how to make decisions in situations like this. What is important to know is that when Mr. Lindsay made this decision, there was already a decision by a board ALJ on the exact same issue. And Judge Mary McClatchy, 3 months previously, had decided that in the absence of a rule, an agency does not have to accept a withdrawal of the resignation. Additionally, there was guidance from this court. In the case of Harris v. State Board of Agriculture, this court said that the only right a state employee has to withdraw a resignation is if that right is found in rule. Mr. Lindsay's decision was consistent with both of these opinions. It is certainly impossible for Mr. Lindsay to know that another ALJ a year later would interpret the exact same rule in a way to permit employees to withdraw the resignation at any time, whether that be 2 days after they submit it or 2 hours before they walk out the door on their final day. It was perfectly reasonable for Mr. Lindsay to make the decision he made based on the information available to him. And this lack of notice is what's wrong with the board's decision. Rules serve a purpose, and the board cannot just make things up as they go along and create new rules without notice and comment to the stakeholders. As discussed in the amicus brief of the state agencies, the interpretation of the rule has had a tremendous impact on cost of how state agencies do business. It would be unfair and unreasonable to expect Mr. Lindsay to have made a different decision in light of what authority and guidance was available at the time, especially since his decision was supported by the law and the record. It is not Mr. Lindsay who took away Ms. McCauley's right to withdraw her resignation. It was the personnel board when they repealed the rule and removed the right.
Well, counsel, there are other arguments too, one of which would be the estoppel. Why is it on the website that she had the right to withdraw her resignation?
Well, what was on the website was a handbook, an old handbook that was there that basically addressed all employee issues. It was very clear in the handbook that it was there as a guide, but as pointed out in the ALJ's decision, there was a caveat at the front of it that said the source of the authority is in the actual rule. So the handbook itself was not updated. The rule had just been changed about a year prior, and so the handbook wasn't updated, and that was just one of many rules on there. Certainly, Ms. McCauley had other sources to go to find out the information on the rule, and state employees are required by board rule to know the rules that govern their employment.
To what extent was the ALJ and the board's decision influenced by the constitutional provision, the state constitutional provision?
In the denial of the motion for summary judgment, and to correct Mr. Finger, it was a motion for summary judgment, not a motion to dismiss. In the denial of the motion, Judge DeForest explicitly relied on the Constitution and said there's a constitutional right to keep their employment for the entirety until it ends. And Judge Tyberski, in the initial decision, she relied entirely on what Judge DeForest said. So to me, it appears that the judges completely relied on the Constitution and felt like that's the source of authority for this decision that employees can rescind their resignation at any time. Now, counsel admits in his brief that the Constitution doesn't say anything about that, and in the statute it doesn't say it, so the only source of authority would be in a board rule, and that's not the case here. Getting to the supplemental authority that was submitted, cert was granted on this, so I don't think, it doesn't have any precedent here yet because it's not a final case. However, I believe the case strongly supports the department's position. The case, first of all, relies on the Berruman decision, which is exactly on point in this case here, as discussed in our reply brief. It's the same situation where the board took a board rule and interpreted it in a way that added a new condition on state agencies. The other thing about the supplemental authority is it's deference. I believe that's why it was cited, was because the deference to the state agency. Well, the reason why the court gave deference to the state agency is because there was an advisory bulletin that the state agency put out interpreting what that rule means. That advisory bulletin had stakeholder comments, it had notice to everybody, so everybody would know that this is the way the department is going to interpret their rule. Additionally, paragraph 39 of the supplemental authority, it says that for authority to be persuasive, the interpretation must be consistent and contemporaneous with other pronouncements of the agency. Here, we have two different ALJs interpreting the repeal of the rule in two different ways, so there's absolutely no consistency and no notice. Regarding the second issue in this case, it also involves two contrary decisions by board ALJs. Following Judge DeForest's denial of the department's motion for summary judgment, Ms. McCauley submitted a request for attorney fees for the department's denying her continued employment. ALJ Sanchez took over the case, and she issued an order denying the request for fees, saying that it was premature since there was no final resolution in the case. When Judge Tyberski took over the case from Judge Sanchez, she also made statements to indicate the need for final resolution and said that due process demands that we have a hearing. Mr. Finger stated that an ALJ offered it to bring the appeal up to the board. I didn't see that anywhere in the record, and it's not in his brief, so I'm not clear exactly when an ALJ would have offered that. However, the ALJ, when she issued her summary judgment, she could have put appeal rights. She could have made it an initial decision that's right for appeal. She did not do that, and she even recognized that it should proceed forward through a hearing. Many statements from all three ALJs on the case saying that it needed to go through a hearing, it needed to go through this process. There are no rules that provide for an interlocutory appeal or any kind of appeal halfway through the case, and so there was nothing for the department to do but defend its position, defend its legal position that was brought against it in the appeal by Ms. McCauley.
You had said in the preface to that comment that the ALJ could have given appellate rights. Is there a 54B-like provision in the board rules that allows for a bifurcation of a distinct issue for appeal purposes?
There's not explicitly, but however, when there is a situation at the board where it's a purely legal issue, with its interpretation, the board certainly could issue their order in a way that makes it a final decision, knowing that this is purely a legal issue, and so I'm going to put the appeal rights, I'm going to call it an initial decision and permit the parties to take it to the board. That could have happened. There's nothing, though, rule-wise that would have permitted that.
Counsel, what about the question that Judge Howard raised of opposing counsel about, do we even have jurisdiction to entertain your challenge to the validity of the board's action here?
Absolutely. I believe the Supreme Court's Department of Corrections case makes it very clear that it's in the interest to move these cases forward. And, listen, this case has been sitting here. It started in 2014. It's been 4 years. The ALJ sat on it for 10 months before she ruled on the motion for summary judgment. The board is the one that decided that they'd put appeal rights on their final decision of the agency and permit the parties to appeal to this court. The intent here is for the board to get this final resolution, and so in the interest of judicial economy, in the interest of the saving money of the taxpayers and the time of the parties, it makes sense for this court to decide this.
It does make sense in some respects, but let me ask you, was the case you cited to us, was it dependent upon deference to the agency's interpretation of their own statute?
It certainly was.
And so where do we have a board interpretation of a statute saying that this type of decision, as opposed to, say, attorney fees decision, would be appealable at this point?
The decision of the board, where you understand that the board feels like this case should be moving forward is the appeal rights they gave. They didn't need to give appeal rights. In other cases, they certainly have put in there, and Mr. Finger cited a case, which is a little, it comes from both sides. It says the case is remanded to decide a fee or cost issue, yet that decision gave appeal rights. The board certainly knows how to do that. The board certainly could put their language in the order saying we want to remand it to determine fees or costs or whatever, but they didn't do that here. They gave appeal rights, they let the parties appeal, and it's Ms. McCauley who filed the appeal in this case. So, there is deference to the board in that they gave appeal rights, and they're the ones who are responsible for making sure that these state personnel board cases move quickly through the system.
So we have, again, I'm kind of equating this with a 54B style motion in a civil proceeding. If we as an appellate court are asked to review an issue after the trial judge has made a 54B certification, we don't just accept that that was an appropriate certification. We look at the issue of whether it finally resolved the merits de novo, correct?
Correct.
Why would we give more deference than to our own trial judges on whether something is final and giving us jurisdiction? Do we give deference to a state agency on whether we have jurisdiction?
The state personnel system is unique in that it's governed completely by board rule, by the Constitution, by the statutes. It's very clear and laid out how these processes work. And so the state agencies are generally given in deference in how they enforce their rules and how they enforce the statute. And so deference should be given to them when they decide that it should or shouldn't be appealed.
But whether something is final and appealable for our jurisdictional purposes, jurisdiction being challengeable at any time, is that interpretation of their rules or is that interpretation of our rules?
Oh, well, it's an interpretation of both, but it's the board rules that shape what your interpretation should be. You need to look at what their authority is in order to permit an appeal on this. And certainly the Department of Corrections Supreme Court case is very clear on the deference given to the board on the rules on this type of issue.
But wasn't that case nothing more than an application of existing law within the court system? In other words, attorney's fees as costs aren't going to hold up an appeal. But this is damages, not attorney's fees as costs, correct?
Correct.
So wouldn't that be a different analysis?
I don't believe it would be. I believe it would be the same analysis.
Yeah, wasn't the Department of Corrections case an interpretation of a statute
Correct.
to which we were supposed to have given deference to the agency's interpretation?
That's correct.
Okay.
Fortunately, on the fee award, the board got it right and reversed, and as discussed in our briefs, there's numerous legal reasons why attorney's fees are not appropriate here. What this case shows us is that board ALJs are not on the same page.
Why? Why were they not appropriate, since we're going to talk about it for the next 42 seconds?
Why were attorney's fees not appropriate?
Why were you not stubbornly litigious? Why was the department not stubbornly litigious here?
I would start with saying there is no case law that shows that a defendant who continues to put forward their legal argument is being stubbornly litigious. There's absolutely nothing out there. The cases Mr. Finger cited all had to do with appellants and plaintiffs who brought those cases. So to start with, there's no case law supporting it. Second of all, the chilling effect you'd have on a department knowing that they had to abandon all opportunity to come before you to discuss the legal issues would have a huge impact on the way we run state business. You cannot run a case if you think that you can't go forward on challenging something that you believe is wrong.
Okay, counsel. Thank you for your
Thank you.
argument. Your time has expired.
Thank you, Your Honor. The proposition that there were differing administrative interpretations by ALJ is not in the record as part of the decision-making process of the appointing authority. appointing authority made no reference to knowing about Ms. McClatchy's decision. That was a decision by the ALJ that did not go to the board for review. It was not brought up. There was a pro se individual employee that was involved, and therefore there was no board determination to know about. The ALJ, the appointing authority didn't know about it. That is not a consideration for the reasons for the rejection.
Is it still appropriate for us to consider it when we're deciding how much deference to give?
No, because the board didn't make that decision. This was an ALJ preliminary decision of a pro se individual who was unrepresented and couldn't present arguments as to why, really why legally, in any sophisticated manner.
Mr. Finger, where in the record did the ALJ offer the,
I cited it in brief, Your Honor, and gave you the reference. It's after the summary judgment determination that the ALJ said that they could go forward, and I did cite that in the factual aspects of the case.
so in your factual recitation in your opening brief?
I think in the reply, because the opening brief didn't fully cover all the facts, that was part of the record. Mr. Morsher's argument about the retraction of the rule is what was posed at the board, that the retraction of the rule took away all rights to rescind. There's nothing in the record that showed that. The ALJ made that finding after looking at the record. Further, the rule's history is in part set forth where the rule
Counsel,
is,
your time has expired also.
had 15 seconds.
No, if you keep watching,
I'm over?
you're in the red zone now.
Oh, pardon me then.
No, maybe
I will
one of these.
I will not comment on that then. I appreciate your pointing that out.
Thank you, counsel, for your argument. I want to thank both counsel for their arguments in this case. The case will stand submitted, opinion will issue in due course. That concludes our business for this morning. The court will stand in recess, subject to call, and the bailiff shall so announce.